I'm Spencer Mazyck, and joining me now is John Siegal. He's a partner at Baker Hostetler who represents filmmaker Ken Burns in response to the City of New York subpoena seeking unused footage from Mr. Burns' new documentary called The Central Park 5. Welcome, John. Thank you for joining us today.
Thanks for having me, Spencer.
So before we get to the subpoena, let's talk a little bit about the film, The Central Park 5. Right. What is it about?
Well, this Central Park 5 is about the notorious case of the rape of the woman who became known as the Central Park Jogger, but it really focuses on the 5 then young men, now men, who were convicted of participating in the crime, served their full prison sentences for those crimes, and then their sentences were vacated in the early part of the last decade after someone else confessed to the rape, and that confession was consistent with the DNA and other physical evidence. And so the then District Attorney of Manhattan, Robert Morgenthau, moved to vacate the sentences of the 5 men. And it's really about their experience. It's really more than anything a human portrayal.
About their experience of being convicted and now in their lives and journeys today?
Well, and also, how did this happen?
Okay.
I mean, you watch this film, and as a lawyer in particular, or as a parent, or just a citizen, you say, how could someone confess to a crime that they now say they didn't do? Mm-hmm. And every time when I was watching the film, I'd say, how could they do that? And then the film would take you through the next step of what occurred and try to piece that very difficult saga together. I found it very powerful just at a human level, as well as a story of legal interest.
Yeah, and I want to emphasize that these 5 men, they've been exonerated, but they're also now plaintiffs in a lawsuit against New York City seeking $250 million, right?
Yeah, they have a lawsuit against the city, and which I'm not involved in in any respect. I represent Ken Burns, Sarah Burns, and Dave McMahon, Florentine Films, which made this film, and in responding to the subpoena. But the subpoena has been issued in that civil suit that the 5 men have pending against the City of New York.
And to be clear, that suit has nothing to do with them trying to determine their innocence, right?
Well, I'm not involved in that. I don't have a viewpoint on that, but I do think that a case for wrongful arrest and a civil rights claim based on wrongful prosecution, to some extent, is going to examine the evidence of what occurred or did not occur.
So the City of New York served your clients and the production company with a subpoena in September, and then a slightly narrowed version of that same subpoena again in October. What exactly are they seeking?
They are seeking all video and audio recordings in the possession of the filmmakers of anyone who had any involvement in the incidents in April 1989, or in the criminal prosecution, or in the civil case, including they're seeking interviews with expert witnesses in the civil case when expert witnesses have yet to even been designated. So we wouldn't even know
who they are.
They're seeking essentially all of the outtakes from the film, except for a few interviews that they excluded. There were interviews of mayors Koch and Dinkins, of a social psychologist, of a historian. That they're not seeking, but anyone with any involvement in the cases or the incident they're seeking.
When your clients have objected to producing this information, why?
Well, my clients are reporters. They're investigative reporters, and they gathered this material not for some lawyer to use it as a shortcut for discovery in a civil lawsuit, but to report a story. And reporters are protected by the reporter's privilege, which imposes a higher burden for a subpoena for a reporter's records than for an ordinary third-party witness. And we feel it's very invasive of their reporting process when the City of New York, which refused categorically to participate in this documentary in any form or fashion. Every city person, police department on down, who was asked to be interviewed by the filmmakers said no. And yet they're seeking all of the outtakes of the interviews of the people who did cooperate.
Well, and John, as you know, though, the city has made several arguments for the production of this information. First, they argue, that your clients do not qualify as independent press primarily because of public comments that were made by filmmaker Ken Burns, where he is seemingly acting as an advocate for the plaintiffs. How do you respond to that?
Well, Spencer, I don't think that you or any of your colleagues here on the Bloomberg channel are no longer journalists simply because you express an opinion on a story that you're covering. I don't think that a columnist or an editorial board is not protected as a journalist because they have a point of view. And the same is true of documentary filmmakers. They researched and reported this story as observers, as reporters. They developed a point of view in the course of that reporting, and yes, a sympathetic point of view towards these individuals. But that doesn't remove from them the protection that we as a society and a legal system provide to journalists.
Well, what about the argument that Sarah Burns, who, as you mentioned, is the daughter of Ken Burns and also a filmmaker in this, she's the director here, what about the fact that she was a researcher and a paralegal at a firm that represented 3 of the plaintiffs during 2004 and 2006?
Yeah, Sarah was a paralegal at the law firm of one of the lawyers involved in the case as a summer job during college, where she did a little bit of work on the case. She went back to work at that law firm later after graduation, but did not work on this case. But all of that predates her reporting for this movie. The interviews of the plaintiffs, of the individuals, their family members, all of that occurred after she left that law firm and in the course of reporting a story that she was writing about and making a movie about. So the brief stint that she had as a paralegal is really irrelevant to this as far as we're concerned.
Well, and the city has also argued that this case is analogous to the Chevron Berlinger case, where the Second Circuit actually ordered and held that the filmmaker there had to produce outtakes to Chevron by virtue of a subpoena. So how is your case different from that case?
Well, first of all, the Berlinger case is just a terribly troubling decision for everybody in the media business.
How so?
It's an aberration. It's an outlier. They found that Joe Berlinger was not acting as a journalist because of his alliance with plaintiffs' lawyers suing Chevron in a case involving a situation in South America. It's an aberrational case. It's an aberrational case really because the court found that he had been solicited to tell this story by the plaintiff's lawyers, and that he had to some degree ceded editorial control of his movie to the plaintiff's lawyers when he showed it to them before it was closed and agreed to excise a scene from the movie at their request. That is an entirely different situation than here, where people independently researched and reported a story. And their interactions with the plaintiff's lawyers in the course of doing that were only in terms of interviewing them as sources for the movie. So in that sense, it's totally different. And the notion that a documentary filmmaker or an investigative reporter or an editorialist is somehow open to government subpoena because of their point of view is a very dangerous precedent, and we need to make sure that the court limits that Berlinger case to its particular and probably unique circumstances.
Is it at all clear why the city of New York here is seeking this information via subpoena instead of deposing the plaintiffs directly?
Well, I don't want to speculate on the reasons that the other side in a legal matter is doing what they're doing. The fact is, though, Spencer, you're right. They haven't deposed these people. They'll have the opportunity to depose them. I can only assume that they're seeking this material because they want to use it for the depositions. Now, in those instances, narrow, specific, limited instances where journalists are compelled to produce material pursuant to subpoena, it's usually much later in a case, after there have been depositions where the issues are very clearly and specifically defined, and the party serving the subpoena can make a particular showing that a particular piece of information is relevant to an important issue in the case. They haven't made any of that showing here. They're simply looking for inconsistencies, impeachment material, stuff they can use for the deposition, and we think that's too broad and way broader than the law in the Second Circuit permits.
Well, and your clients, again, have refused to produce this information, so where do you think things will go from here?
Well, there's going to be a hearing a week from Monday, which the court just set today, and that's going to determine our motion to quash the subpoena, and hopefully it will be quashed or appropriately limited, and that'll be the end of it. But we're before the magistrate judge in a case that's pending before a district judge, and so there could be proceedings beyond this depending on where it goes.
Okay, and before we go, I want to ask you, how did you come to represent Ken Burns and his production company?
Yeah, I did some work with Ken a number of years ago. He had done a film on Jack Johnson, the first African-American heavyweight champion. And in the course of that, I got involved through him with a committee of political and showbiz and fight celebrities, essentially.
Athletes, yeah.
And we researched and wrote a petition seeking a posthumous pardon for Jack Johnson. That was a pro bono project that I did with colleagues out of historical interest, but that a relationship developed with Ken and people around him, and so now when this arose, I had the chance to get back involved with him and litigate this.
Yeah, and you also represented Anthony Weiner in the wake of his 2011 sexting scandal.
Well, yeah, I also represented him for years before that in a lot of positive things.
Right, but I was going to say, is it more challenging, or is it challenging representing clients that are in the news?
There's no doubt it adds an element of attention, of interest. You know, the press attention here to Ken's subpoena, I think, is helpful in terms of getting out the word of the existence of this film and the existence of the case, and I think it's engendered a really fascinating public discourse in New York about an event that really epitomized a time in this city that is recent, but when you see the film, seems like a long time ago, almost in another time and place.
So much.
And it's a really fascinating discussion, and the film includes a fascinating media criticism of what the public discourse was at that time and how these men and the crime were characterized, which I think is a very valuable contribution and is a valuable and productive public debate.
All right, well, thank you very much, Don, for joining us today. We really appreciate it.
Good, thank you for having me.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.